this question that's just come in from one of our audience members today. Perhaps, Laina, you want to start us off? Adam, you're more than welcome to give your input as well. But the question is, what is preventing funds who have lawyers among their employees giving a formal second opinion, and in that way, presumptively, avail themselves of the attorney-client communication privileges?
Oh, I guess, okay. So the question is basically, can the funder act in a capacity as another lawyer or another counsel to the client? And I think that the dynamic of the funding transaction really kind of prevents that in a way, because ultimately the funder and the client are going to be counterparties to a contract. And so they're really going to be, although their interests are aligned in terms of the case going well, on the funding transaction, it's really important for it to remain an arm's length transaction, where it's a clear line that's drawn between the client and the funder, and that the client is clear that they have their counsel and that is the party that is giving them legal advice. And while the funder's input can be important and valuable, that there's not a mistake over who is actually the lawyer and who is actually the client. I'll let Adam add to that.
That's succinctly and well said. I'm not sure there's a lot I can add. And I accept to say probably I'm not sure I would want that opinion on the other side to be structured that way, not because I wouldn't value it. I'd value it a lot, as I said earlier in the presentation, but I'm going to get all of that value anyway from the ordinary underwriting process and implicitly from the decision whether to fund. Creating a second paper trail of it that's maybe going to expose things to discovery, I suspect is only going to complicate things.
Thank you so much. And this next question here, it dropped in a couple of times, albeit asked in slightly different ways during today's presentation. But Adam, it dropped in first while you were speaking. Perhaps you want to be the first one to lead us off with this. Now, a lot of the discussion this afternoon seems to be around funding on the side of the plaintiff. But what about defense side funding? Have you ever seen that? And if so, how does it work? And what are perhaps the nuances between that and what we've discussed this afternoon?
Well, I'll say I've certainly had clients ask about it. I've not had experience with it in practice myself. My understanding of it, and Laina hopefully will weigh in here in more detail, is that it's usually achieved. So the obvious obstacle, right, is there's no pot of gold at the end for a defendant winner from which the funder could take its cut. And similarly, from which the firm, if it's operating on some sort of notional partial contingency, could take its. So I think that the way this often works in practice is that the costs for the defense claim are tied to or cross-collateralized somehow with either an offensive counterclaim in the same action involving the same parties, or in the case, if that's not available, with other plaintiff side litigation that might perhaps be wholly unrelated that the funded defendant has, that allows the funder to secure the investment some other way. Was that right, Laina?
That is exactly right.
Excellent. And we'll close with this question. It did drop in while you were talking about best practices and what have you. And Laina, it relates to a point that you raised earlier about perhaps someone may have concerns that a funder is perhaps pulling the strings, as it were. What would you do if you were presented with a red flag that perhaps suggested that?
What would I do if I were in the client's shoes? If I were in the client's shoes, I think that I wouldn't enter into an agreement with that funder. I think that you would have a good sense from the process of dealing with the funder and coming to that agreement, and then also from the explicit terms of that agreement, whether that funder is going to try to exercise control. As I mentioned, and ask around, get feedback, understand from other lawyers and other litigants who have worked with that funder what their experience was like, I think is really important. We're happy at Validity to get our clients and lawyers that we work with in touch with others with whom we've worked, and that they can get comfortable that that's that they're not going to have to be concerned about. That would be my suggestion. You know, it was to try to suss that out before entering into the agreement. The process of looking at a case, it's a pretty in-depth process that can take, you know, a couple months. And so during that, a lot of interaction between the lawyers and the client and the funder, where everybody really kind of gets to know each other and understand how upfront the other parties are, and whether they can trust that they're going to abide by these kinds of unwritten or sometimes written rules. So so that's what I would say, is that during that process, just pay attention and make sure you're comfortable with who you're working.